How's that? Thank you all very much for your testimony. The purpose of this hearing today, and the theme of it, if you will, is security and liberty. And I would first like to thank you for your contribution to that debate. This is obviously something that's one of the most important deliberations that we're going to have to deal with. And also, while I'm at the thank you both for your years of public service and for your contributions to not only the profession of the law, but also for the administration of justice. We're all very grateful that you're here. We're sorry that Professor Hyman can't be here. Had a series of questions. I was curious to hear him in a debate on his book, but we'll perhaps have that for another day. It's the juxtaposition of the concepts of security and liberty that are the major focus of today. And while we ponder which recommendations for future actions we have to take and what we want to recommend to the leaders of this nation and to the citizens of this country. And I hope it goes without saying that when we focus on the horrible acts of 9/11, that we must be careful that our anger doesn't lead us to overreaction, and that our fear of future plots doesn't cloud our judgment as to the measures that are really necessary to protect and prevent any such future acts of terrorism. We must be aware, and we have to all collectively, both witnesses and us, be sure that our recommendations to provide security are consistent with the need to balance and preserve the elements of liberty, which are really the bulwark of our governmental system. It would be horrible if we don't do that, and then the terrorists would have a second victory that would be far beyond their wildest notions of success. So with that in mind, I've got a few questions I'd like to ask you. You know, at the end of the day, our job is to make recommendations. And in trying to formulate this, it's why we are so grateful that you're all here. I've got a few areas of questioning that I'd like to pursue, and then in deference to time, I will turn it over to my colleague Tim Romer, and I must tell you that also my other colleagues all have questions they'd like to ask you, so I'll proceed with just a few. I'd like to start with you, Larry Thompson, just because you had just discussed changing the law and maybe refining or the value of redefinition of the law under the Patriot Act. I think, as I recall, there's a recent Ninth Circuit decision on this, but there have been some concern about the application of material support law, especially to individuals who contribute to organizations and are unaware that the money may be used or has been used for terrorist activities. And I would really appreciate any guidance you can give us as to whether you think this is a significant problem, and if so, how we might be able to rectify it. And Professor, I'd like you to also comment on that as well.
Yes, Mr. Feilding, you referenced the Ninth Circuit case, and if I can recall, that case held that certain parts of the material support statute were unconstitutionally vague, especially as it related to providing one's own services, one's own persona, if you will, to participating in, for example, a terrorist training camp. And the legislation that I referenced in my written testimony, my written statement, and what I mentioned briefly this morning would clarify that to make it clear that if you go and participate in a terrorist training camp and an activity, that clearly provides material support to terrorism. To your point about the need to make certain that we do not change the fundamental character of this country as we deal with terrorism, as Congress has passed more laws to give the government better tools to fight terrorism, I agree with that. And with respect to the Patriot Act, I recall reading just recently some comments by Senator Dianne Feinstein in which she said there's been a great deal of concern, concern and angst and misinformation about the Patriot Act. She said that she called the ACLU's office and asked the ACLU to provide her of any instance of an abuse by the Department of Justice of the Patriot Act as it has been recently passed and implemented by the Department of Justice, and the ACLU told her they were not aware of any abuse, any instance of the law being misapplied. And the point I'm making here is that the important electronic surveillance and search provisions of the Patriot Act are subject to judicial review. They're subject to judicial scrutiny, and no lawyer will sacrifice or jeopardize his or her career by making false statements in affidavits in support of search warrants, in support of applications for electronic review. I think that's very important, and I think it's needed. But the point is that with respect to the Patriot Act, I believe that there has been a great deal of misinformation. The act has not been discussed in the dispassionate and reasonable and informed manner that I think it's needed to be discussed. But most importantly is that some very important provisions of that act, especially Section 218, which has allowed the government to expand its coverage of suspected terrorist activity subject to judicial approval, that provision is going to sunset. And I think it would be a terrible mistake to allow that provision to sunset.
Thank you. Professor?
Thank you. First of all, specifically on the material support statute, I think that no one questions the importance of cutting off material support to terrorist organizations. The problem arises when people who may have inadvertently given material support find themselves at the bottom of a ton of bricks because having given material support, they're treated like the first assistant to Osama bin Laden and facing sentence of life imprisonment. So what we need to do with the material support statute is to be sure that these very, very severe penalties are targeted and limited by law to people who have knowingly given material support, and that people who have inadvertently given material support are either subject to very modest penalties, or I believe in the case of protected First Amendment activity should not be subject to any penalties at all. The flow of the money can be cut off by the government itself in targeting those charities which have a mixture of terrorist and legitimate activity. The government can target that without treating the inadvertent contributors as the worst criminals that are out there. That would be number one. Now, I do have a number of disagreements with my good colleague here, and it may be that I disagree with the ACLU because I do think there are some significant problems with the Patriot Act. Number one, I think it's true that we're not aware of much because so much secrecy surrounds the way that Patriot Act provisions have been applied. So I would have to say as well that many of the things concern me. I can't give you a specific example because the Justice Department has not told us and has not told the Congressional Oversight Committees either how many of these provisions are being applied. An example, something that was an example, was Section 215, which gives the Justice Department access to business records and non-business records, including records, membership records of religious organizations. Library borrowing records has been the one that's been most controversial. There's been a big hullabaloo about that, and the Justice Department for many months refused to say how often it was being used. Finally, they revealed that it had not been used at all. Well, so I guess one could say that it's not an abuse, but I think the fact that it hasn't been used for more than 2 years suggests that it's not so necessary, and that the chilling effect a provision like that inevitably has probably outweighs the benefits. More broadly, and I may be going beyond your question and reflecting the comments of my good friend here. More broadly, I believe that number one, there are instances where we have to balance. I think it's quite true that there are instances where there is a trade-off where we may, at least from one perspective, be sacrificing enormously important liberties for the very long term. This is a war likely to last for much longer than any other. Sacrificing very central liberties for a very tangential, speculative gain. But that is balancing. More often, it seems to me, the choice is simply a false choice, that we don't necessarily need to give up liberty to get security. And in fact, I think the assumption itself is very misleading, because I think the public tends to assume that if we are giving up liberty, then we're getting security. People take that for granted. And because that so often that isn't the case, it's an assumption that's actually quite dangerous. I think it's understandable that people have these intuitions, and I think it's understandable they have the preference to be secure at any price. I myself live and work in Lower Manhattan, and I feel that intuition, I believe, as strongly as anyone. But most often, it's a false choice. I think an example, just to give one, accountability measures have been a source of great frustration to the Justice Department because they take time, they take paperwork, they're a distraction, or they appear to be a distraction. And the Justice Department has often said we need to simplify and short-circuit these checks and balances so that our agents can devote themselves to investigative work on the ground. But the solution to that is not to sacrifice the rule of law so that we can free our personnel for field work. That's the seeming dilemma between liberty and security. But the simple solution is simply to provide sufficient resources so that we have enough agents and enough time to allow for accountability. Israel, for example, faces at least as serious threats and at least as severe resource constraints as we do. But very recently, their Supreme Court confronted exactly this issue, and they said that a shortage of personnel doesn't justify curtailing checks and balances. What they said was, when there are emergency conditions that demand a large-scale deployment of security forces, then by the same token, the government has to devote comparable effort and resources to preserving accountability. So that would be one of, I believe, many examples where this choice becomes a false choice. And I think protecting soft targets would be another example of where we can be both free and secure if we're willing to devote resources.
Thank you very much. I trust that the headline tomorrow will not be that you disagree with the ACLU. But in regard to the Patriot Act, this is obviously something that we're going to have to deal with in some way in our report. And it's also very clear that this is a very volatile issue and one that's subject to extreme debate. I would really appreciate your comments, both of your comments, as to how we should address this. I know that Mr. Thompson, I believe about a month ago, you made a suggestion in a speech that maybe there should be a commission appointed to review this. I guess we all have our views on commissions these days, but that certainly would be one alternative. But as we address this, we would appreciate your guidance as to how we should address it. We obviously can't be in a position where the commission votes 6-4 to repeal 218 and 7-3 to do something. So we need a mechanism. So could I draw upon your experience and your judgment on that, please?
That's a very important question, and it's one that I'm struggling with as I am now a private citizen and I'm out of government and have to interact with fellow citizens about what the country is doing in responding to the terrorist attacks and talking about the Patriot Act. And the one thing that is frustrating, and the professor mentioned accountability. I don't know how more accountable Department of Justice lawyers and FBI agents can be other than under oath signing affidavits that there is probable cause to conduct a search, that there is probable cause to believe that an individual is engaged in an international terrorist activity, and therefore obtaining an application for electronic surveillance under the FISA statute. I don't know what additional accountability you can have. That's the traditional way to be accountable in our criminal justice system. That's the way prosecutors and agents have been accountable to society for years. But the point is, we have a great deal of suspicion out there about the Patriot Act. We have a great deal of, I think, misinformation. And Mr. Feilding, what I think is critically important and what I hope this commission would give us advice and counsel on is that we cannot, as a country, allow at least some of the very important provisions of the Patriot Act to sunset without a greater, more reasoned, less political, and more informed discussion as to why we need them in our war against terrorism. And I agree with the professor. I do think that we have to have a national consensus, if you will, as to what the government is doing, and people need to be comfortable that we're going to pursue, the government is going to pursue its important public safety and national security measures in a fair and impartial way. That's important. But what is happening with respect to the Patriot Act and the debate that we're having, I'm very frustrated about, because it's a debate that's permeated with a lot of misinformation, sometimes false information. And I did suggest that we have a commission of legal scholars, practitioners in the national security and criminal enforcement area to study the provisions of the Patriot Act that are going to sunset. And if we're going to have something like that, it probably would be better not to have it in 2004, where it would be subject to some of the political considerations that are obvious. But it needs to be ready to go after the election so that Congress can get the benefit of a dispassionate, reasoned, and informed advice as to the efficacy of some of the provisions of the Patriot Act. Again, I personally would support all of the provisions that are scheduled to be sunsetted to continue. But I think that's something that we need to look at very carefully, and certainly provisions like 218 that are so important to our anti-terrorism efforts cannot afford to be allowed to sunset without the kind of discussion that I'm talking about.
Thank you. Professor?
Yes, I think on this subject there's probably far more agreement than disagreement between the two of us. Number one, I think it would be wonderful if we could take that debate out of politics, or at least to a lesser, turn down the political temperature on that debate. And if a commission or a panel, perhaps delegated by the judiciary committees of the Congress, to develop a report would be a way of perhaps lowering the political temperature a little bit, I think it would be very constructive. On this, I agree completely. There's an enormous amount of misinformation. I think the issue has been overly politicized on both sides. The ACLU, I think, has exaggerated some of the problems. I think on the other side, the Justice Department has, to some extent, exaggerated the benefits. I'm surprised when, for example, the changes, proposed legislation to under the national security letters, there is an important need there to expand the definition of what is a financial institution for purposes of national security letters and bring that up to date. That's fine. But that proposal was announced by the President of the United States in a major address. That seems to me surprising. I don't understand why something of that technical nature should be elevated to the level of a politically salient kind of issue. This is where I think we could all benefit by lowering the tone a bit. There is misinformation, but I would highlight on the substance, first of all, there are many provisions of the Patriot Act, as I mentioned, that give the Justice Department powers to be used in investigations that are entirely unrelated to terrorism. And the Justice Department's report on the Patriot Act actually acknowledges this and brags about it, I guess you could say, identifies a number of investigations, including an extortion inquiry, a gambling, a narcotics inquiry, where new Patriot Act powers were used in a conventional criminal investigation. Now, maybe there's a case to be made for that, but if there is, we should take it out of the debate about terrorism and make the case a freestanding case on its own terms, why the sneak and peek search powers and several of these other powers should be used for conventional law enforcement. With respect to Section 218, I agree that some change in the wall and some change in the significant purpose requirement is appropriate for terrorism investigations. I do not agree that those changes are appropriate for conventional criminal law enforcement. And the fact is that the Patriot Act expansion of FISA powers is now available to the Justice Department for any criminal investigation. In fact, when the primary purpose is to investigate prostitution in New Orleans or gambling in Montana. All the FISA provisions can be used as long as the very broad conception of foreign intelligence, which, as I believe the Commission knows, covers a very large waterfront unrelated to terrorism and even unrelated to hostile foreign powers. Those are there. So that's an example. Larry Thompson, I think, appropriately suggested that we should try to be specific about where more accountability would be appropriate. Without sort of extending my answer, I would just give a couple of examples because I think it's fair to want to be concrete about that. The national security letters, of course, involve affidavits, but they bypass the courts. A number of the administrative subpoena provisions bypass the courts. The demands for documentary evidence under FISA have much more limited judicial oversight than we would conventionally require outside of the foreign intelligence area. So anything that's FISA is much less accountability. There's some accountability, but it's much less than we would traditionally require. FISA is exceptional. It's an exception to our normal regime, and we should do it where it's appropriate, but we should be careful about whether it is appropriate or not, because that's a dilution. And the last one I would mention is not a Patriot Act example, but the enemy combatants again. There is no accountability there, none, absolutely none. The concept of the rule of law disappears completely if you accept the administration's position that they can seize a U.S. citizen right here in the United States, and that by the president's determination that the person is an enemy combatant cuts off all access to the courts, to the press, to counsel, to anything whatsoever. That is a substitution of the judgment of one person. To be sure, it's our commander-in-chief, but it is nonetheless, it's the judgment of one person without any outside accountability. That's one I think that sorely needs to be rectified.
Okay, thank you. Let me just ask one final question of both of you, and I'm going to switch gears, and you can put your prepared text down, because you have expertise in this area, and one of the major problems that we're going to have to decide at the end of the day is whether we should recommend a change in our domestic intelligence gathering. Some of the concepts have been to have an MI5 type of an entity or something like that. If you could each give me, or give us, your views on that succinctly, I'd appreciate it. Mr. Thompson?
Yes, Mr. Feilding, I think it would be a terrible mistake to create a separate domestic intelligence agency, if you will, if I understood your
Yes.
question to indicate that that's what
That's correct.
you
Thank you.
propose to do. And I explained my reasons more fully in the written statement that I prepared, but what we have here in terms of how we're going to deal with terrorist activity in this country, and this gets in response, is a response to something that the professor said, is that you need to have an integration of your intelligence, investigative activity, your counterterrorism investigative activity with your prosecutors. They need to be talking to each other. You cannot have FBI counterterrorism agents pursuing an investigation, not talking to the prosecutors, and not knowing what available criminal statutes, and they do not have to be the material support statute, it may be some other kind of statute, but what kind of available criminal statutes are out there that when a decision is made that this person has gone too far and that we've exhausted our intelligence capabilities, we need to take him off the streets. And what we were having before is that because of lots of reasons and because lots of walls, there was no integration or there was not enough integration in our efforts. And so our counterterrorism agents were not talking to our prosecutors, sometimes because they were trying to hide information improperly, sometimes because they were afraid to do so. And you need to have this integration. We need to have the Section 218 help bring the walls down. I would respectfully submit that the creation of a new agency would bring the walls back up. I visited the United Kingdom, and I've talked to officials at MI5. They have a much different legal system, and what has developed over there is appropriate for their system. There are only 40 some odd different law enforcement agencies for the MI5 to deal with. Here we have thousands of different agencies. The FBI is doing is undertaking a restructuring that I think is going a long way toward emphasizing intelligence, emphasizing greater analytical support. So I would say it would be a big mistake to do that.
Thank you. Professor?
Yes. On this subject, I'm afraid I have more questions than answers. I find it a very, very difficult and troubling issue. I agree that we have to be very careful not to create more walls and more barriers. Most of the barriers are cultural and organizational rather than legal. And nonetheless, if you create a different agency, you run the risk of exactly what Larry Thompson just described. The problem, I think, with the FBI is that because it has had a traditional law enforcement focus, its orientation and training and perspective on problems is different from the intelligence gathering function. FBI agents are excellent at building a provable case and sensitivity to evidence that will be admissible in court. It's a different perspective, and I'm not sure whether we can turn that ship around and create a new culture within the FBI. There are also, I think, bureaucratic imperatives here in Washington that even if we knew what the ideal solution was, I'm not sure that we could get the sufficient political momentum to get people on board for it. One of the proposal I've seen, which I think has some attractiveness, is to create within the FBI an intelligence function that whose director would report more or less directly to the either to the DCI or to some individual that would have a more proactive role in integrating intelligence. But in other words, you could have housed within the FBI, thereby addressing some of the bureaucratic momentum, but housed within the FBI, an organization that would have a different culture, training, recruitment, and perspective, that would have more of the quick, creative, imaginative, proactive kind of culture that I think you need for an intelligence agency. But with that said, I'm, I think, as puzzled about this problem as anyone else.
Thank you both, gentlemen. Mr. Chairman.